Remember, Caesar, thou art but a man. Listen courteously, answer wisely, judge fairly. Those are the words of Socrates. And when you listen courteously, you've got to keep your mouth shut as a general rule. Don't speak or interject unless you do so without anger or visible emotion and in a calm, respectful tone. These are things I've made up to say to myself, remind myself of.
Okay, my name is Steve Nebaker. I'm here with Judge J. Thomas Greene in his chambers in Salt Lake City, Utah. And the date is March 8th, 2006, and I'm here to interview Judge Greene in connection with his service as a United States District Court judge for the state of Utah for approximately 20 years, going on 21 years. Judge Greene, to get started, I'd like to just ask you about your background. Could you give us a little information about your personal background?
Yes, I was born in 1929, just after the crash, and I remember it well from what I've read about it. But that was 1929 in the month of November. And I've lived in Salt Lake City all my life. Went to school through the public schools, and you went to grade school, Roosevelt Junior High, and then East High School. I then went to the University of Utah and studied political science as an undergraduate. And after a 2-year mission for the Church of Jesus Christ of Latter-day Saints, I came back and finished up going to summer school and finished up within about 5 quarters after that, and was able to enter law school and did that at the University of Utah. I had a lot of regard for Francis Wormuth, who was a professor of political science, as well as Homer Durham. And I talked to both of them about going to law school. Durham was quite supportive of that. Francis Wormuth said it would be the craziest thing that I could do. He said that it's like trying to herd cats. So judges and you shouldn't get involved with the lawyers. It would be a mistake.
Was there one particular event that prompted you to decide to practice law?
Well, what happened is that I went to see Spence Kimball, who was then the dean of the University of Utah Law School, and they were just starting the SAT test. I believe that's the name of it, aptitude test, and I took it, and I didn't pass it. It didn't show me with an aptitude toward the law, and that was a challenge. And I talked to Spence Kimball about it, and he told me that he had failed it because he had taken it, not that it was in effect before, but he had taken it just for fun to see what would happen if he was a student. And so that gave me some reason to think that maybe I could overcome my inaptitude, or ineptitude, whatever it was. But I really just wanted to study law. I still had in mind maybe becoming a professor. I was given a scholarship at the University of Pennsylvania to study political science, but I turned that down and decided I would try to become a practicing lawyer.
As I recall, you were on the law review at the university.
I was on the law review and worked on that for the last couple of years that I was there.
And what year did you graduate from law school?
I graduated, actually, I took the bar exam. They only gave it once a year. And they let me take it while I was still going to school in the fall of 1954. And so I was able to graduate at the end of 1954, and I was able to get the results of that bar examination, which was, I was allowed to get through it. And so I was sworn in January of 1955. And I got my degree finally in June of 1955.
About 6 months after you'd passed the bar. Tell me about your law practice. What course did you pursue after you got through with law school and got the bar behind you?
Well, I decided that I would try to practice law, and I didn't like the idea particularly of going with a law firm. There weren't a lot of opportunities to do that. Maybe that's the reason I decided not to do it. But I practiced alone for a while. I sent out a little card in one of those little teeny brown envelopes. It must have been quite a spectacle to receive my announcement in my first card as a lawyer. I wanted to take antitrust cases, and I was going to limit my practice to antitrust. And after a while, after I didn't get any antitrust cases, I decided maybe I'd go into something else. And finally, I got going into whatever I could get. And I practiced with Woody Crandall for a while. Greene and Crandall. We took some criminal cases, and they were quite interesting. I took a lot of criminal cases on the defense side before I went with a law firm, which was Marr, Wilkins and Cannon, and that was about a year and a half after I started to practice. Before I went with Marr, Wilkins and Cannon, I practiced by being a clerk for Justice Alan Crockett. I was clerking for him before I actually got my law degree, but I continued on, and then I had half a day with Irwin Clausen, who was a lawyer, and he gave me the benefit of a secretary and an office if I would do legal research for him, which I did. And so I was really doing 4 things at the time. I was working at night for the Skyline Oil Company, looking at abstracts, and I was working for Irwin Clausen in the afternoons and Judge Crockett in the morning. And then I was taking cases, and I went to all of the, I think there were 7 Third District Court judges. I went to each one of them and asked them to appoint me, if they could, to felony cases so I could get some trial experience. And they did that. All of them did it, and I got some amazing cases. I tried 2 murder cases. They were both in the prison, deaths that had occurred by one way or another there. Other prisoners had been involved. And then I had some other cases that were quite notable, but I won't get into that. It lasted for about until the time I went with Marr, Wilkins and Cannon, and I went with them for about 6 months And I had the arrangement that they gave me an office down the hall if I would supply them 2/3 of my proceeds from practicing, and then they would give, and I received a rather modest salary from them during the time, and that's how I made it for about 6 months. They didn't have a windfall from my 2/3. 2/3 was not a large sum, and 1/3 was a very paltry sum that I was able to retain.
Now, at this time, had you become married?
Yeah, I became married in the March following being admitted to the bar.
So that would have been March of '55.
Yes, right. And
Your wife's name?
and my wife's name was Kay Buchanan, and she came from Richfield. We met on a debate bus. We were both debaters, and she said that we've been arguing ever since, but I think there may be some truth to that, but we've gotten along quite well, actually. The fact is, we just celebrated our 51st wedding anniversary.
Can you tell me what positions you held before you became a judge? I'm talking about, of course, positions with the bar.
Well, I was involved in bar work a great deal, and you and I used to kid about the committees that we both attended, Supreme Court Rules Committee and bar committees, several. I was president of the Utah State Bar in '71, and then I got involved in the American Bar Association as a delegate at large. It was the lawyers in 3 different states would vote to put a couple of delegates at large, and I was able to get that appointment. So I became active in the House of Delegates in the American Bar, and then later became involved in the environmental movement, and I was chairman of a bar committee, National Bar Committee on the environment. And then I got involved in the general practice section and other sections, and finally the Board of Governors, which is the governing body.
And how long were you on that board?
I was on that board for, I think, 7 years, as I recall, and part of those years were before I became a judge, and I think about 2 or 3 of those years were after I became a judge that I still continued on with the Board of Governors. I was also a chairman of the State Building Authority, and the only thing I really remember about that is the Wells Building. We worked on the bonding of that, and the construction of that building was just amazing. It's probably the best built building in since Fort Knox. It's really quite a thing. But I did that, and I was a member of the Board of Regents, and as I say, several positions with the American Bar.
How would you characterize the nature of your law practice while you were with Marr Wilkinson Cannon?
Well, it was fundamentally a business practice. We represented a large mining company, United States Smelting and Mining Refining Company, and several coal companies. And I did a lot of that work. We represented the bank, what's become known as Zions Bank now. It was a merger of 3 different banks, and that happened at the time I was there, and I kind of carried the books for Cy Wilkins, who did most of the actual putting together of those banks, and of Gib Marr. Marr was the main bank contact, and he was sort of the godfather of Roy Simmons. And he was looked at by Roy Simmons as a very important confidant and helper. He didn't do a lot of the work, but he did a lot of the lobbying for all of the banks while he was active.
Did you have any concerns about leaving the practice of the law to become a judge?
Yeah, I really did. I was certainly not dissatisfied with the practice. It was really the height of my practice. When I became a judge in 1985, we had practiced for 10 years in a merged firm with the Collisters. Lou Collister Sr. and his son, and Gary Howe and one or two other individuals joined with us in a merger which at that time was the successor of Marr, Wilkins and Cannon. Mm-hmm. It was known as Greene and Nebaker. It was Greene, Nebaker, and Horsley, and then we added the Collister names. By the time I became a judge, we had about 40 plus lawyers, and we were beginning to have a rather substantial firm.
And I believe you were the senior lawyer in the firm at that time.
I think that's right. I was the chairman of the board that we incorporated, and we did a lot of not only bank work, but all kinds of financial institution work. And I did a lot of trial work in the firm also.
You mentioned to me a little earlier this afternoon that this desk that you have behind you here was the desk that Cy Wilkins said he wanted you to have. Was that a desk that he used when he was practicing and passed it on to you?
That's right. He had that desk in his corner office, and when he pulled the rolling part of the desk down, you knew that the interview was over. At the end of the day, he made it known that he wasn't taking anything home. And he made that point to me several times. I didn't learn it very well because I took work home. But yes, he told me he wanted me to have that desk, but he didn't want me to have it before he was not using it.
So you kept it through your 20 plus years while you've been a judge.
I have. I've always been fond of the desk. It used to be a desk of the mining company, and it had quite a history. And Cy told me about that once, but it goes back to the turn of the century. And it's a great old desk. And I had it up at the law firm after Cy became all counsel to that firm for a while, and Paul Cannon did also, and then Lou Collister Sr. was all counsel. But then we created the firm of Greene, Collister, and Nebaker, and that was the name of the firm when I went onto the bench.
What was the judicial selection process like for you?
It was that system where they had a group of citizens, and it was something that came about as a result of a campaign promised by whoever was the Republican. I guess it was Nixon, who said he would follow the recommendations of a panel. And so I think there were 25 people, and I met with them, and so did anyone else who were interested. And I did that twice. I was a token Republican in a field of Democratic candidates, and I was one of the 3 or 5, I can't remember which one, who were named as possible selectees, but I was the token Republican. So when I did the process again, it was the second time, and I really had about as much as I could take of that sort of thing. And, but that's this time lightning struck, and so that's how I happened to get lucky enough to be appointed.
It was the same process, though, going through a selection committee,
Yes.
being recommended to the president,
That's right.
and then he made the selection and appointed you judge.
He made the selection from the 5. Of course, there were the senators really didn't have the kind of say on that by their own agreement that they do now.
A different process.
A different process altogether.
Mm-hmm.
And I think that selection process may have been abandoned all over the country. It was tried in many places, but it became a political thing, I believe. But I wasn't aware of it when I was there. I was never much into politics, and I really didn't think I had much of a chance to prevail, but I was lucky enough to be selected.
Looking back on your 20 years as a trial judge, and this may be a difficult thing for you to do, but can you select 3 cases that you think were what you might call seminal cases as far as you were concerned?
That is hard to do. I had so many cases, and some of them were very notable. I'm not going to mention anything about the abortion cases, but that was a deep involvement. And part of the rulings were favorable to the state of Utah, but most of them were not. But the cases I might mention would be, I tried an Indian murder case. It was not too long after I became a judge. I think maybe about the 3rd year or so. And it lasted for 7 weeks. And it involved the murder of 2 tribal officers, Bureau of Indian Affairs officers, who had come upon a group of Indians who were having a very raucous party near a place called Promise Mountain in the Navajo Indian Reservation. And these officers came upon what they thought was a beer party, and it was getting out of hand, so they told the people there that the party would have to be over and that they should all go home. And they had other thoughts about that, and they decided that those 2 officers were the ones that were going to go home. And they did the unspeakable act of tying them up, putting them in their own van, dousing it with gasoline, and really cremated those poor individuals. Mm. And then pushed the van down to the river and pushed it into the river, hoping that it would never be found. That was a very involved case. It seemed like half the reservation came to Salt Lake to see the trial. Those in favor of the prosecution and the victims would sit on one side of the courtroom, and the others sit on the other side that were backing the families. There were 6 families and about 8 defendants in the case. It was something that I learned a great deal about the Indian culture, realized of many things, that when an Indian doesn't look you in the eye, that's a sign of respect, not a sign of anything else. They think it's disrespectful to look you in the eye. And I learned another thing about Indians, that even though they may have signed an affidavit about what the facts are, they didn't think that was binding on them in any way. And if you ask them their current version, it wouldn't be anything like the previous version. So it was quite a trial, and it resulted in conviction of all but one of the defendants. That's one of them. Another case that more recent, got involved in was that West High choral group case, and that attracted a great deal of involvement and attention nationwide. Those who were backing the establishment clause, the wall between church and state, were on one side, and those that were backing the free exercise of religion clause in the First Amendment were backing that clause. I was in the middle of a trial when these people came into my courtroom and had to have they said, a ruling right now about whether the West High group could sing the song, "May the Lord bless you and keep you," and whether they could sing the song called "Friends," which was objectionable. They said they had to have a ruling right now, and I was at a break. I looked at the papers, and I said, well, if you want a ruling, you've got it. They can sing. Let them sing. I don't see any reason not to sing. This is a Jewish person who is objecting. That happens to be the verses from the Jewish Bible, right from the Old Testament. So anyway, they got on a plane and went over to Denver and they could only get 2 judges, but the 2 judges entered an order staying the effect of my ruling. And it wasn't until there was an en banc hearing of the whole thing after I had ruled that religious choral music is not does not violate the Establishment Clause, and that was a notable result to some all over the country. I had somebody who writes a national column write about that and said that maybe there's some judge in a faraway place, even like Utah, that seems to have some grasp of things that are real. So he was a little bit outspoken that way, but
The case got a lot of attention.
the case got a lot of attention nationally, and it was a long case, and it involved several aspects in which we had to have a rehearing on some aspects of it. But anyway, that was a case that involved a lot of my time. I remember the librarian at the university was one of the witnesses, and he admitted that he had advised these people that they could go ahead and sing. And I said, before you say anything else, do you think you would like to have, would you like me to read your rights? You don't have to testify if you think you're incriminating yourself. Well, he said, I'll testify anyway, so he did. Another case that I had that was quite notable, I think, was one that involved Upjohn Pharmaceutical Company. It had to do with a drug that they had developed that was a mind-altering drug. It was Halcyon, and that drug was alleged to cause people to get an unreal feeling and do things that they otherwise wouldn't do. The case I had happened to have been a case of a woman murdering her own mother, allegedly because she'd taken this drug. That's when I got introduced to the barcodes and how you could have depositions taken all around the world, and there were dozens of depositions in this case. But you could then code it down, and if somebody was testifying about some narrow point, whoever else had something to say about that matter could instantaneously be brought up, and you'd hear all of what every witness who had something to say on that subject was right before the jury. I thought that was amazing, and we did it in real time, and it was a lot of the high-tech stuff that we do now was introduced to me in that trial. The trial didn't come to fruition because the case was settled before the jury could act upon it.
Have you seen other cases where that technology has been used?
I have, and we've used it in other cases. A couple of ERISA cases we used it. But it's, in talking to the jury people afterwards, and I tried to see what they thought about it, I got an answer that they'd rather not have that technology. They felt like they were being talked down to or being educated on something they didn't want to be educated on. They'd rather have a live witness come and tell me about it. And I'm not sure that that's the universal reaction, but it was in two cases that I had, I think, the reaction of the jury.
Do you have what you might call a metaphor or a story or concept that kind of epitomizes your philosophy as a judge?
Oh, goodness. I've had occasion recently to reflect on being a senior judge and what it is that informs judicial philosophy. I don't know that I have any one thing, but I have felt that judicial activism is one thing, the rule of law and what it is really underpinned by is another, and there are two or three other things that inform my conception of judicial philosophy. On activism, you know, you can have an activist attitude in being a judge in the way you handle the case. And federal judges are allowed and encouraged to ask questions and can ask questions where state judges may not have that kind of a situation. So the role of the judge in the trial of the case is one form of activism, which, if done properly, seems to me to be entirely appropriate. And activism in the development of the law and in the reform of law is another conception. That is a form of judicial activism. What is usually talked about and what they really mean when they say avoid activism is activism in decision making, trying to legislate from the bench, so to speak, and that's what judges are told not to do. When I was before the Senate on the matter of confirmation, Strom Thurmond was the chairman of the Judiciary Committee. And the only question he asked me was, are you going to be an activist judge? And I knew what I thought he meant. he didn't tell me what he meant, but I think I knew. But anyway, I said no. I really feel like I would be an activist judge. I probably should have said yes, but I didn't mean that I would override, legislate. I would actively decide cases, and where you come across a case that there's no precedent for, it's the common law. Anyone who's come across that problem is an activist judge. He has to fill in the gaps. As Cardozo said, you need to inform yourself of the history, analogous precedents, and then your own sense of justice. And if that's legislation, that's legislation, but you don't go beyond it and make it a class action. It's just to decide a case.
You do have to fill in gaps where there's no authority.
Yes.
For you. What would you say would be the most influential person in your life? That's another tough question.
That is a really tough question. My father influenced me greatly, but he never said that he was teaching me something. It just came. I developed a conservative view on a lot of things because of him. Maybe in driving, and in his statement to me once that it'll be just one moment to forget and a whole life to remember if you make a big mistake in the way you drive. So be careful. And I kept thinking about that. And even with my necker knob, I was careful. I tried not to...
not to abuse it.
I tried to actually park the car before I started into my amorous affair. Don't get me wrong. Yeah, I think that my father was of great impact in my life. He died shortly after I was on a mission for a while. And in coming back and getting into the law, I really had a close relationship with Justice Crockett, and he helped me in a lot of the things that I did. And Cy Wilkins was a great role model for me, and he helped me in my view of the law and getting through cases. Sort of surrogate parents in a way.
If you hadn't practiced law and become a judge, what type of career might you have pursued?
Well, I always thought I was going to be a college professor. And my dad said that he thought maybe I'd be a good college professor because I like to talk so much. That didn't really cause me to want to be one. But I did apply for graduate school with the University of Pennsylvania, and they awarded me a scholarship that was very tempting. It was in political science. It would have been pointing a career toward teaching.
In political science,
in political science, perhaps, or perhaps international affairs. But the more I thought about that, the more I decided that I really didn't want to do that, and I didn't. I was accepted and given a scholarship at Harvard, but I really wanted to stay home and support my mother, who was a widow now then, and in talking to Sandy Kadish, who was a professor at the University of Utah, as well as Spence Kimball, the two professors that I felt closest to, they convinced me that they could give me as much learning as I'd be able to digest. And they pointed out that the top students at Utah could rank with the top students any place in the country. And they had some evidence of that. And I believe it was true. It wasn't so much that I wanted to be the top student by any means. I just wanted to get an education in the law. And I got thinking, and I went to some trials, and I attended some trials while I was in law school. Maybe you did too. Mm-hmm. And I remember one particular involved a partner of yours,
Paul Ray.
Paul Ray.
Mm-hmm.
He cross-examined a person in court, and it was an excellent job, and it kind of gave me the real desire to be a lawyer like that. He was very polite. He was very effective, and he had a bit of humor as he went along. Mm-hmm. I thought he was really a good lawyer.
Looking back for the 20 years that you've been on the bench, can you say if there's been an evolution in the change of the practice of the law or in the lawyers that appear before you over that 20-year period?
Yes, I really can. I think there's been a very great change. Going back even beyond 20 years, I think there's been a whole change in the foundation of our whole society. I think the mores have changed. I remember in 1969 when I was special counsel for the grand jury, one of the things we had was some very graphic and very disgusting pornographic cases. I don't think they could have been more graphic than they were. And the foreman of the grand jury, after we'd heard all of this and they were ready to vote on an indictment, he had been in San Francisco, and he said to his fellows there, you know, we saw some graphic things here, but I saw a lot of more graphic things in San Francisco. It cost me about $2 to see it, but it was there, and it's available, and nobody's going to jail for showing it. And I don't think we ought to indict. Mm-hmm. And they refused to indict, and that told me that something has changed in our whole attitude toward such things. And I think that's true with a lot of things that have happened. But for instance, the vanishing trial. When I started being a judge, I had non-stop trials. I had a trial just about every 10 days. And there were others ready to be tried. Nationally, both civil and criminal cases were up almost to 10% of the cases that were decided, and they were decided by juries and by trials. Recently, to see the trend, it's down below 2%, It's closer to 1% of all the trials in America, and it's true here, are handled or decided by juries or judges in a trial. So there's a vanishing trial situation that's gone on.
Criminal and civil cases?
It's true in criminal cases as well as civil cases. In criminal cases, it seems like the prosecutors have been offering deals that are hard to refuse. And when a person who's indicted realizes the amount of time that could be attached, and they're given an offer to have the indictment dismissed and to plead guilty to a lesser charge, they take it 9 times out of 10. That was when the guidelines were mandatory, but the same situation is just about there now. I think most of the judges are consulting the guidelines, and even though they are not mandatory, they're being followed almost, I'd say, more than 50% of the time.
And that's just a recent change.
That's a recent change. Yeah. A change between the mandatory and discretionary. Guidelines are now guidelines.
What they're supposed to be.
That's what they should have been initially. Our court sat in banc and bonk and decided that the Guideline Act was unconstitutional. It didn't prevail.
Reflecting on the judges that have been on the bench here before you, you've been here for 20 years. You've seen some of the older judges complete their time on the bench and seen a lot of new ones come on. I'd like to have you just comment about some of your colleagues who practiced, who've been on the bench before you.
Well, there were 7 federal judges on the bench before I became a judge, and I practiced as a lawyer before 5 of those 7. I never practiced before Tillman Johnson, but I practiced before Judge Ritter. I was Assistant United States Attorney for a period from 57 to 59, and Judge Ritter was a person that I got to know. In those days, we have such a big United States Attorney's Office today that it's hard to realize that there were only 4 attorneys in the United States Attorney's Office. The United States Attorney, and then he had a civil assistant. Pratt Kessler was the U.S. Attorney. I think Lou Thomas, a lot of people, the old timers will remember these people.
Mm-hmm.
He was in charge of the civil cases, and Nelson Day was in charge of the criminal cases, and Ray Allred, so there were really 5 people. Ray Allred took what would be regarded as collection cases. That's what he handled. Judge Ritter didn't like any of them. He was positively antagonistic toward Pratt Kessler, and the United States Attorney had a hard time getting orders signed. And Lou Thomas, he didn't have much regard for him. I heard him in open court say to Lou, you can come in the courtroom, but I don't want to hear your voice. You can't speak. And Ray Allred, he said, and you can't come in the courtroom. And if you come in, I'm going to hold you in contempt. Now, he may have been kidding, but it sure sounded serious. I became the only person who he would allow to come into his chambers and get orders signed. And it lasted for about a year of that honeymoon. if it was a honeymoon that I had with Judge Ritter, when I was supposed to object in a trial, I knew when to object. He would look at me, and then first he said, "Do you have something to say?" I didn't know what he meant. I said, "No, I don't have anything." He said, "You sure you don't have something to say?" And I said, "Oh, well, I object." He said, "It's sustained." So we got along pretty well, except it was embarrassing to be as against some of the fine lawyers who were practicing, and he would favor me, and he would always sustain my objection when I finally got the idea that he wanted me to object.
He gave you a cue and you followed.
He didn't make me say why I objected, and I didn't know why I objected. I just objected. But Judge Ritter was arbitrary and capricious, but he was brilliant and he was extremely interesting. On a one-on-one basis, he was not arbitrary or capricious, but he was very much the judge and the trial lawyer and the jury all wrapped into one person. I don't mean to say that in a derogatory way, because so many lawyers thought he was an excellent judge, and he was a good judge. He was smart, he was articulate, but he certainly, I remember him as being hard to get along with if you didn't happen to have the same point of view that he had.
But you were on his good side.
I was on his good side.
Good sledding.
Oh, goodness. It was really and truly embarrassing. I really kind of used to wish that he'd rule against me, because I didn't feel like it was right.
Did that carry over from the time you were in the U.S. Attorney's office over till when you were in the private practice? That same good feeling that extended to you?
The feeling kind of left before I left the U.S. Attorney's office. It happened one day, in just a strange thing. He came to the bench. His face was very red, and people had been waiting. He was about 45 minutes late. There was a whole group. Mine was the first case. He said, "What have you got?" And I said, "It's a sentencing, Your Honor, a tax case." And he said, "Well, tell me about it." And I told him about it. And then I pointed out that the sentencing file was there, and the sentencing report is there on the bench. He said, "I don't care what's on the bench. You tell me about it." So I told him a little bit more about it. And then I said, "And that's about the size of it, Judge." And he said, "Well, you know, I have to screw it out of you to get me to tell me about this case." And so I tried to tell him about it again, and he said, "Well, that's insufficient." Then he walked off the bench. And it was a different relationship from that time on. He was not as forthcoming to me as he had been.
For some reason unknown to you.
For some reason unknown to me. I didn't really know what I'd done, but it was something. It was an incomplete explanation, I guess.
Did you also practice in front of Judge Christensen, I think, who was appointed after Ritter and became another judge? It
became a two-judge court, and I practiced extensively before Judge Christensen. After I went on, left the government as well as before, Judge Christensen was understanding of the situation I was in. I remember Judge Ritter was in the throes of a divorce, a contested divorce. He was on his ear about a lot of things. And when I first had cases, he said, "We're going to try 5 cases today." And you've got the subpoenas out. I said, yes, they're all out. He said, well, we're going to try 5 cases today. We'll pick 5 juries right now. And I was going to give an opening statement. He said, I don't want to hear anything, an opening statement. That's just lawyer talk. I want to hear the evidence. I want to hear the evidence. And I will hear the evidence. And he said, and we'll try these 5 cases. We'll put 4 of those juries in rooms, and you folks can wait. You won't be long. We'll get to you. We'll try all 5 cases today. And we did. We tried 5 cases. There were no opening statements. There were no real strikes. He asked the lawyers if they were willing to accept the first 12 people. And in one case, that's what we said, yes. I said, oh, I'm sure I will.
These
Your
were all
Honor.
criminal cases.
They were criminal cases.
Mhm.
And the assistant United States, the defense lawyer was willing to do it too. Then we did take our peremptory challenges, but he wanted them taken right immediately. And he took up the whole jury panel. Judge Christensen didn't have any jurors at all, and he had called some cases for trial. But we tried those 5 cases, and they were all tried, and they were all. I think one was acquitted. The rest were convicted. Judge Christensen, I tried cases before him. He had to resort to having a marshal go out on the street, on Main Street, and every 5th person that walked by was tapped to be a juror. Mm-hmm. And the marshal took these people into the courtroom, and Judge Christensen talked to them, and they became the jury in his court. I had on several occasions the same supposed to be in both courts at the same time, and Judge Christensen went along with it a couple of times and said that he would work with me. But he said, I'm not going to just take a back seat to that man. And he didn't, and
Did they ever communicate, you think?
I'm not aware of them ever communicating. They might have. They sat on, they had the 3-judge panels those days, and on certain cases, and they sat together. Whether they actually talked to each other was hard to tell. But it was not a pleasant thing, as you may know, and I'm sure you do, that we went to the circuit court to get this was Judge Christensen sent this in writing. I didn't go to the circuit court, but the circuit court received the recommendation of Judge Christensen that there be a splitting of the cases, that every other one would go to one of the judges, that it wouldn't be assigned by the chief judge as it was. Mm-hmm. Judge Ritter was assigning the cases that he wanted to himself, and the rest to Judge Christensen. Judge Christensen didn't like that, and the circuit got into it and entered an order of assignment of cases, and I believe it's still in effect today. It isn't followed exactly, but
the basic
idea is still
chief
there.
Judge doesn't have
as it happens, everything is so pleasant now. There's no disagreement with Chief Judge Benson. There wasn't any disagreement with Halden Anderson or with Bruce Jenkins when they were chief judges, or with David Winter. So it's a non-issue now, but it was a big issue in those days. Judge Christensen, I should say, was an eminent judge, and he became a member of the special court in San Francisco. As you may know, it was a specialized court. He took that assignment. He started the American Inns of Court movement, And I was just really pleased to be able to become involved in getting the nomination for Sherm Christensen of all of the judges in America. I recommended and moved that he be given the American Bar Association Gold Medal, which goes to one person every year. And the first year that I made that recommendation, I failed. But I got a lot of them knowing that I was going to make that same motion the next year, and they remembered it and they agreed with me, and Reed Martineau was involved in this, and he was bar president at the time, and together we got everything together and made a presentation to the Board of Governors that they bought, and he became the recipient of that gold medal. Well deserved.
Judge Greene, while we've taken a little break, you have mentioned to me something that we didn't discuss before, and that is that during the time you were a practicing attorney, you were appointed as a special assistant to the Attorney General's office to handle some railroad cases. Could you just tell us a little bit about that, please?
Sure. That was the time when across America the railroads were discontinuing passenger service. They were trying to be relieved of the necessity of having a passenger service train. And they were doing a lot of things to discourage passengers from. And so I was hired to represent the state in opposing the train-off cases. And I went to every one of the hearings, and we lined up witnesses who were passengers on trains, and everything we could do to try and convince stopping this wholesale movement. Well, I got into something. You know, the ICC doesn't generally allow a discovery. It takes a special dispensation from them to permit the conducting of any discovery.
That's the Interstate Commerce Commission?
The Interstate Commerce Commission. I applied for that, and they surprisingly granted it. So we took the depositions of the chief operating officers of the Southern Pacific, of the DNRG, of the Western Pacific, and of one other railroad. The Union Pacific was one of them, yes. And it was apparent from these depositions, the candor that they gave, was that there was a virtual conspiracy among the railroads to discourage passenger service and to make everything from failing to clean the place to running the trains late and many other things to discourage passenger service. Well, I got real excited about that. We had a big deal in Salt Lake where the railroad officials were here for another purpose, but I was taking depositions, and the paper was giving me more discussion of what was going on in this lawsuit as compared to what they were trying to do as a group in some other respect. I got called into the governor's office, and the governor said to me, I thought, well, gee, this is great. I thought I was dealing mostly with the Attorney General, but now the governor's going to give me some encouragement. So I went in there, and what he said to me was kind of amazing. He said, what are you trying to do win? And I said, well, yeah, isn't that what is that why I was hired? He said, that's the last thing we want you to try and do. We want to let the unions know that we're trying. We want to let them know that we've hired a lawyer. But we don't want some kind of a lawyer saying that you're going to have a conspiracy or that you're violating the antitrust laws. And I see that you said that right on the record in one of your proceedings. That isn't what we want to do. We have these railroads, and we need to have their goodwill. Now, I don't want you trying to win any of this case. Just attend. And you don't need to be on the front line. You don't need to ask for any depositions. Just go and attend and say you're representing the state of Utah.
I bet you haven't had any other clients that have given you that kind of a mandate.
My goodness. I thought, well, this is reality. I could not believe my ears, but that's the way it was. And the Attorney General had a different point of view, but the governor had the real power. The last word. So I didn't get to take to file a motion before the ICC, which I'd prepared to demonstrate what was really going on. Not that they wanted to hear it anyway.
I see.
So anyway, that happened. And the same thing, I was also a Special Assistant Attorney General for highway matters. And one of the big problems was the freeway going right by Salt Lake. It was falling apart. It had bad materials in it. I don't know if you remember that. But we brought an
the
action.
interstate. We're talking about
The interstate highway in Salt Lake was defective and had to be virtually replaced. And we brought an action against the contractors on behalf of the state of Utah, as well as the architects who had filed a very large bill for their services. And we developed that, and I won't go through all of that, but a lot of work done, depositions taken, and we really had a case that was good. But I was called in to the highway department, and they told me the facts of life. I thought I was being called into the governor's office. They said, look, what we want is for the state of Utah to get paid. That's what we want. So what you need to do is to switch gears and go on the other side, get all of their information, and I'll arrange to have you present this matter in Washington on behalf of the state of Utah, which is acquiescing in the claims that the architects are making and that the contractors are making. They need to be paid, and of course the state of Utah will then not have to pay any part of their bill, and it will mean a lot of money for the state. I went to Washington and we presented the matter, and they said, oh, well, I didn't know you had this kind of documentation. Yes, I can see that, and we'll take this under advisement, but I think you can rest assured that we will be looking favorably on this. They paid their bills, and everybody was happy except the attorney.
We also talked about the changes that you've seen as a judge. You mentioned how many cases are being tried now as compared to how many were tried when you first came on. Do you have any comments about the lawyers that appear before you?
Well, I think the attitude of lawyers toward each other has noticeably changed. I think filing of motions to disqualify is not uncommon at all. It's virtually a two-track case. There's a case on the merits, and the other is a case that the lawyers have against each other. And that is not an overstatement. It happens in more and more cases. It was unheard of when I first started to practice law, and for the first several years of hearing about a lawsuit against another lawyer. I even thought it was unethical to do that. I know Marcellus Snow thought that. He told me, right in his chambers once, I was trying to get heard on a motion to reconsideration. He said, "But you're trying a case against a lawyer.
Can't do that.
You can't do that. This is a member of the bar. And I'm not going to grant your motion. Heavens, no. This is a lawyer." But anyway, I've noticed things like the growth of paralegal involvement in lawsuits, the growth of alternative dispute resolution matters. It's grown decidedly. In the kind of cases, intellectual property law has grown. Civil rights cases, which were never even thought of, have become a big part of the whole court's docket. And sexual harassment cases, for instance, discrimination cases of one kind or another, whether it's age or sex or now sexual orientation is getting to be a big thing. So these are things that have come up and exist as a part of the docket. In criminal cases, if you take away drugs and guns and immigration, you're taking away 75% of the people that are in jail in the whole system. So we're talking about a massive change in the criminal aspect of things. In the civil aspect, antitrust used to be a very large thing, and it's going to be more now, but it's been replaced by such things as wrongful termination cases and employment cases. They're very large. There's a difference in the kind of cases that are being tried. We keep a pretty close yearly analysis of the kind of cases in our district, and it's very interesting that certain things have grown and continue to grow, and others are on the decline. The Civil Justice Reform Act was part of this, and we had teams who were doing the things that were being advocated, things that were already being done virtually by all of the judges in our district to try to improve the quality of justice. That Civil Justice Reform Act encouraged a lot of early settlement discussion, more pretrial practice, less discovery, and cut down on discovery and develop discovery plans, permit only a certain number of depositions to be taken.
You think that's been a good piece of legislation?
Well, I think that it was meant to be a good piece of legislation. As it turns out, the things that were being advocated, and they spent a lot of money on this, and they had the RAND Corporation and others looking into it and analyzing what was done. And then they compared it with the lawyer lawyers who were not involved in these programs, and some were and some weren't, and they compared them, and they found that the end result of getting the case disposed of and taken care of was not much different whether you were in the plan or not. And the reason that it wasn't much different is the kind of things that were being advocated were already being done in place.
You've had some rather significant responsibilities, among other things, of swearing in immigrants who were newly admitted to citizenship in the United States. You have a photograph here that you were showing to me before we started this interview, and I'd like to have you just explain what the photograph shows.
This is a photograph that was taken up at the University of Utah during a naturalization ceremony. It involved, I think, 300 to 400 persons who were being sworn in. And you can see them in the stands behind these American flags and the other flags. This is sort of an action photograph that shows what was being done on the field. But what we had done was we set up a table right on the football field, and during the halftime we held court. We called the court to order, and we had two persons who represented all of the immigrants give a short talk on behalf of everyone. It wasn't going to be practical as we try to do in other settings to hear from everyone. But these two people were representative, and they gave very inspiring talks. They were meaningful talks, and it was quite a situation. It was actually it was the 200th anniversary of the coming forth of the United States government in 1988. I remember it really well. I'd only been a judge about 3 or 4 years, but I was doing the naturalization ceremonies during that year, and Nedra Mortensen was in charge of getting things together, such as little pom-poms for all of the people being naturalized, and she did a great job in getting some physical things, like a little booklet together that had things about the American experience. But it was a great thing, and this is sort of a photograph that brings it all back to me as I think about it.
Judge, one other question that I'd like to ask you that has come to my mind as we've been talking, and that is, what is the hardest thing you think you have to do as a judge?
You know, I thought that being a judge would be something like the practice of law, where you would have certain conferences with your senior partners and make decisions jointly. I was used to doing that, but it never happened. You're a sole practitioner.
You're on your own, so to speak.
You're on your own, and the last thing the other judges want to hear is something about your case, because they have problems, just like every one of us have. We have a docket that is demanding. I sometimes have wondered how it could be possible for any person to do properly and in a great way all of the things that are expected of a federal judge. You know, we're generalists. We don't have any expertise in a lot of things that we're called upon to handle. And we have insisted upon rotating these cases. If there are 3 cases involving virtually the same matters, we don't try to bunch those up with one judge. We have 3 judges, and it's been very good in the sense that it has made it very broad, and you get a broad perspective. But it's very hard to get the background together. And thank heaven for the excellent briefs that we receive from counsel. It's very difficult sometimes to do what needs to be done for pro se people because they don't present their case in a way that is very lawyer-like. But you have to realize that and try to help them get their case across. But on the other hand, they're bound by the rules of practice just like everybody else is. And the best thing we can do is to just tell them what to do. But the hardest thing you ask, the hardest thing for me was giving up the practice of law, being an advocate, being in the arena, so to speak, not having the sweet pleasure of the attorney-client relationship, which I think was a wonderful thing. In 30 years of practicing law, I became very fond of certain clients. And I'm sure that anyone who practices has had that experience. Now we find intake sessions by the paralegal. We find other things being done that supposedly are saving money for the client. And it gets to the point where it's the client doesn't really get to see much of the lawyer who's really going to be handling his case. I think until they go to court, but even then they wonder about it, and I think the matter of communication is so critical for lawyers. I've had quite a bit to say about that from time to time, but I think what the client really wants isn't so much to win as to be told what you're doing. And to be part of the team and to be kept advised and knowing that you're on his side. That can be lost if you overemphasize the commercial aspects of the practice of law, which sometimes it seems like we're going in that direction. I think we need to fight against that. So that's probably my comment on what was the hardest thing to do. I got thinking the first couple of years, what have I done? What have I done? I get into a perfectly happy person.
I'm a good practice for a tough practice.
I liked the practice. I didn't realize I was going to become a sole practitioner, and good heavens.
Well, let me just say I appreciate very much this opportunity to participate in the interview, and it's been nice to have a chat with you and review your history as a lawyer and as a person. And I have to say that I think you had a great reputation as a judge and as a lawyer, and I think you really typified what a good judge and lawyer should be.
Well, you're so sweet and nice to say that. I don't feel like I'm worthy of all that, but there's something sweet about realizing that you can represent the public and make a difference, dispensing justice. Thanks, Steve. I've appreciated your assistance here.
Thank you
Okay.
very much.
Thank you, Steve.
It's been nice to visit
It's
with
been
you.
a pleasure.
I've enjoyed it.
Pleasure. Thank you for all of the softball questions and some of the hardball.
Handled them very well.
Thank you.
Beautifully.